Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are discussing with Wayne Crews, Regulatory Dark Matter. Wayne Crews is Vice President for Policy at the Competitive Enterprise Institute. He is widely published and is also a contributor at Forbes.com. Wayne, welcome to the podcast.
It's a pleasure. Thank you for having me.
So what is this regulatory dark matter that you speak of? I mean, we all know about the regulatory state. Of course, it's cliche to think about bureaucrats running Americans' lives, but you're saying this dark matter seems to be something even more sinister.
Yeah, just a little bit of context for it. Last year the Congress passed 114 laws. And meanwhile, the federal regulatory agencies put out 3,410 regulations and rules. I like to jokingly refer to that as the multiple as the unconstitutionality index. There's 30 regulations for every law. Now, of course, not all those regulations are implementing the laws that year. They're implementing things that came before. But in compiling data like that, I do an annual report called 10,000 Commandments where I survey trends in regulation. But what I realized over the past few years, especially as we had President Obama, and the use of executive power is not unique to him, obviously, but he invoked the pen and phone and was very, very explicit about saying we'll go around Congress if we need to. If Congress doesn't act, then I will act. He set down things like that to big rounds of applause at the State of the Union addresses and in front of the Conference of Mayors. And it got me to thinking, as he was doing these executive actions on, and it turns out they're not executive orders. They're often called executive orders, but they're really other kinds of actions like memoranda and notices and things. But as he did these on immigration policy, whatever one thinks of that, but as he did these things unilaterally on immigration policy and then with respect to the Affordable Care Act, you might recall 2 years ago, well now 3 years ago, in 2013, the IRS issued a bulletin in July of that year saying that all of those policies, all of the Obamacare policies, the employer-mandated Obamacare policies will be postponed, and then later that, and so would the penalty for not having insurance, and then later that year, all of the Obamacare policies were illegal by Department of Health and Human Services memoranda would suddenly be legal. So I started thinking, my gosh, when I add up these regulations or count up these regulations, I think there are a lot of things coming out of the federal agencies that we're not catching, and that turned out to be the case. I started looking at the so-called guidance documents, bulletins, notices, circulars, memoranda. I created this whole word cloud of these things. But it turns out that agencies are now, it's always been a phenomenon under the Administrative Procedure Act, but I think as the federal government is involved in more and more of the economy, the guidance documents are coming to dominate regulation. And so I started referring to this as regulatory dark matter and began putting together little inventories on it. And that's how this all came about.
You say regulatory dark matter. So one way to think about this is these are in effect binding orders, even if they're in government by blog post or a letter or a circular or a bulletin or whatever, but things that become binding. Certainly, if you're included within the verbiage of it, you don't necessarily think this is optional for you
right,
to
you don't think
not.
So you don't think it's optional. Technically, guidance documents are not supposed to be binding because they are to be or often said to be interpreting prior statute and things like that. But look, before I say something else, let me just give a couple. We should give a couple more examples of these, just in case, because I want to.
Just for people listening at home, when you say an agency or a guidance document or an agency circular or something like that, talk about what that means precisely.
Yeah, let's say what that is as we're going, because everybody knows what a law from Congress that's signed by the president is. That's your Civics 101. But then we also have normal notice and comment regulations that are governed by the so-called Administrative Procedure Act. And that means that in addition to the laws we have from Congress, there are the normal regulations coming out of the various alphabet soup agencies, the Environmental Protection Agency, the Department of Labor, the Food and Drug Administration, where I used to work, as a matter of fact, and so on down to USDA and so on down the line. And they all put out, their environmental regulations, their food safety regulations, they're the wetlands and land use regulations and endangered species from USDA. All of those regulations, Richard, go through, when agencies put them out, they're supposed to go through what's called notice and comment. And I know most of your listeners are familiar with all of that, but just in case. But they go through the notice and comment where a proposed rule is issued, individuals get to comment on it, and then there's a final rule issued. Well, interestingly enough, even the ordinary notice and comment rulemaking process is broken. There was just a study from the GAO saying that for 44% of all regulations now that come through the pipeline, they don't get a notice of proposed rulemaking. So that we often talk about the breakdown in accountability between Congress and the voters, and that agencies are issuing so many regulations, but they're not governed by Congress. Well, they're not even getting governed by us in the sense of the notice and comments always being filed. So that I noticed that as being one of the real issues with respect to regulation. But when I started seeing the Obama pen and phone activity, I started looking, and there are a few recent examples of what I call regulatory dark matter, or the sub-regulatory guidances that agencies are issuing that don't even pretend to go through the notice and comment period we were just talking about. You might have heard recently that the Housing and Urban Development put out guidance saying that landlord and home seller, if they denied those with criminal background records the ability to rent or to purchase a home, will be a violation of the Fair Housing Act. Well, that's not in the legislation. That's not in the law. That was not even a regulation. It was just a new piece of regulatory dark matter. A lot of people have talked about the so-called Waters of the United States rule. Our general counsel here jokes that it's the moistures of the United States.
Yeah.
But guess what? That's from EPA. But guess what? That was not a regulation. Everybody talks about it like it was a regulation. It was a guidance, an interpretive guidance from the EPA. Now, in this case, the EPA did solicit public comments as if it were a rule. But guess what? There was a New York Times story earlier this year saying that, EPA had solicited cheerleader comments in support of this rule from environmental groups and things like that, so it was regarded as quite an illegitimate thing to do.
So let me ask you, question you.
So there are a number of examples like that.
Regulatory dark matter, things the regulatory estate is doing to us outside of prescribed rules and procedures per the Administrative Procedure Act.
Exactly, and there are a lot, and I see this as a growing phenomenon and something that's a lot more worrisome because, see, these can easily outnumber rules and regulations that we see. I'd mentioned that 100 laws and 3,000 regulations. The Federal Register every year contains well over 20,000 notices. I put that in quotes. A lot of that is just information or bulletins about agency meetings, or agencies are going on a road show or doing town halls and things like that. But a lot of that includes this kind of regulatory dark matter and guidance and notices and bulletins and memoranda and so on down the line. But I realize that Congress just doesn't have any handle whatsoever on this. We had been, a lot of groups in town who work on free market reforms and individual liberty and small L libertarian issues have been working with Congress on what to do about regulations, like getting Congress to approve agency regulations before they're final, or sunsetting regulations, or doing regulatory reduction commission. I think all of those things are really, really valuable, even if they don't do a lot at the outset. What they do start getting us to do is to write things down. But there have been some legislators, Senator Lankford of Nebraska is one, who became concerned about these agency guidance documents that are proliferating now. And he's held a hearing. He brought the Department of Labor in. Department of Labor is another good example of this. Everybody's talked a lot lately about regulations from the DOL saying that independent contractors are now going to be treated as employees. You've heard that's been a lot in the news. But guess what? Not a law, not a regulation, but a guidance that started out as a blog post. But one interesting thing, Richard, they had a hearing last September to discuss agency guidance documents and the status of them and what they were and how often they're used. And this was a bipartisan hearing. You even had Senator Heidi Heitkamp saying, when you decide you're going to undertake some new initiative to control some aspect of law or the public or daily life, what do you do? How do you do it? How do you decide whether you're going to issue a normal notice and comment regulation through the Administrative Procedure Act, or if you're going to issue a guidance or a memoranda? And the answer from the agencies was, we don't know. And the senators concluded, in quotes, they concluded it's a black box how agencies go about deciding these kinds of things. So I just think this is extremely remarkable. And examples keep popping up. I mean, the one that I just mentioned about labor. Also, this year, this week, you may have heard that the district court ruled in favor of the Federal Communications Commission's net neutrality rules. And now, net neutrality is the idea that the internet service providers should treat all bits as equal. They shouldn't discriminate against content and things like that. Now, it's not the topic of this discussion, but I personally want lots of competition among networks, not just across networks. I like the notion of competition and duplication and redundancy, and I think of the future of the internet as there being multiple networks and networks that are streamlined and dedicated and things like that. So I regard these rules as really, really harmful. But guess what? Buried on page, I think it was 80, of this 400 that's now been upheld by the court as of this week, but buried on page 80 of this 400-page regulation is a declaration from the FCC that says, you know what, we are going to start now issuing advisory opinions, which means more dark matter. So if you're an ISP and you want to invest or you want to make some new business model or some new decision, you need to check with us first, and we'll issue an advisory opinion. So with the stroke of a pen, in this rule, what we're seeing is that the FCC is assuming more regulatory power over the future of Internet infrastructure, and by them issuing just advisory decrees or declarations, you see they effectively are regulating without writing anything down at all. And we're creating a huge mother may I culture in one of the biggest or potentially the most important realms of human endeavor, that of Internet communications in a world where all of us have become broadcasters. Yeah. So it's really ominous to me. And those kinds of things cut across in so many sectors where now the federal government is steering and all the market is doing is rowing. And that's renewable energy. It's banking and finance now. It's healthcare after Obamacare, along with things like communications and cybersecurity.
We'll go back to something you said earlier. Are you saying that and this I think prompts a deeper question? Close to 40% of what the regulatory state is doing is happening, you think, outside of the APA?
Well, it's hard to measure.
It's hard to measure.
It's hard to measure. Here's the thing. Of the rules that allegedly go through APA notice and comment procedures, according to the GAO, it's at least a third of them that don't even get a notice and comment. And then on top of that, it's the assorted guidances that come out of the different agencies that potentially can number in the hundreds. There's subsets of USDA that issue just dozens of guidances. In Medicare, there are just hundreds of guidances that come out, and the sub-agencies will tell you, well, we have a lot of guidance. We don't know how much of it is economically significant or not. You'll just have to check. And then the FDA has a wonderful search engine for the guidance on its website, but they all have these kinds of disclaimers you're talking about. This is not legal advice. However, this is our opinion. If you're out there in the private sector and you need an approval of some process you're doing,
your lawyers tell you to follow it, right?
Your lawyers tell you to follow it, and that is if you have lawyers. And that's one of the issues now with the questions of startups and why is there so much economic stagnation. I think a big part of it is the regulatory state, and we always we always like to say you don't have to tell the grass to grow. You just have to take the rocks off of it. And I think this world in which guidance that I fear, because the federal government is involved in so many sectors now, and it's about to take charge in drones, for example, where the FAA is going to do to the airspace what FCC has done to the internet space. You have the potential for the already embedded agencies that have been there for dozens or 100 years to look at the new frontier sectors where all of our important growth is going to come in cybersecurity, privacy, drones, driverless cars, robotics, artificial intelligence, and come out and make these proclamations. They may start out with ordinary regulations, but in these new areas, it's especially worrisome if they then go down the guidance road, because there's absolutely no control over this stuff yet. There are some legislative proposals to do that we might touch on if we have time, but that's where we stand. It's just that we have this situation where Congress has delegated so much authority to agencies, and believe me, they've taken it. And it's not just that they delegated via the Administrative Procedure Act, but agencies are finding ways to work around it by using guidance and what I like to call dark matter.
When we say the regulatory state, I mean, something I've heard Michael Grava say, former chairman of the Competitive Enterprise Institute or chairman of the board, is what do we mean? I mean, what is it? Can we get our hands around it and start to talk about it in an intelligible way so that we can? I mean, I think your regulatory dark matter is a broad way of thinking. Okay, there's formal rulemaking. Then there's this informal rulemaking, and it seems like, particularly under the Obama administration, not that obviously not the first president to do it, but seems to be the first president to realize there was a lot of informal rulemaking going on. Let's just try to make it a big part of what we're doing in, Obamacare or Dodd-Frank, or now with immigration, potentially with guns, and you're talking about the new frontier of our economy now falling under its sway. So that's one way to think about it.
Fear, actually.
But you say in this paper you've written on regulatory dark matter, we don't even know the size and extent of the regulatory state to begin with.
Exactly. I mean, I'd like to say, the regulatory state that is everything that's not Congress passing a law and the president signing it. But there is legitimate delegation. You can do that, but I was just having a conversation on the Hill about the notion of a regulatory budget. You have to do these things within a framework, the context of a framework of where you think government powers are limited. If you think, if you're like me, government picks a national bird and then leaves us alone. But you have to have some kind of a vision of, there's certain powers things that government cannot do, that it needs to stay out of our lives, and then you delegate power within that rubric. But now we have federal government in control of huge swaths of the economy, of dealing with environmental amenities and regulating health and safety. And you say, how big is the regulatory state? That was one of the things I was looking at. Nobody even knows for sure exactly how many federal agencies there are. When I compile the annual 10,000 Commandments, I use the so-called unified agenda of federal regulations. It has, as of the last iteration, 60 departments, agencies, and commissions. But from the administrative conference, they say there is no authoritative list of federal agencies, and they run up into the hundreds of agencies and commissions that are potentially issuing regulations. And it's important to say too about regulation is when free market advocates or advocates of laissez-faire talk about growing the economy, and that doesn't mean no regulation. There's no such thing as no regulation. It's always your choice of whether you're going to enhance the market and competitive disciplines that naturally come into play in free markets, or whether you're going to rely on political regulation, which is what we get with things like net neutrality, which is what we get with things like the FAA certifying drones earlier this year, or the federal government dominating with respect to privacy and cybersecurity regulations. All the things that we want to regulate, in quotes, whether environmental amenities, health and safety, financial stability, privacy and cybersecurity are all forms of wealth. And in my view, you need markets to enhance those, and sometimes the regulators can freeze things in place and actually undermine them. as in a lot of ways, I used to work at FDA, and I thought our health, denying health claims just meant that the food makers were just going to start advertising taste and convenience and microwavability and portability, and so you'd have the average health quality of food go down rather than up. The whole argument of perverse effects of regulation.
Yeah.
And that it's always important to remember that companies aren't in a vacuum. They have upstream suppliers and downstream business customers, and Wall Street and the media. All these forces are arrayed against companies that misbehave, and a lot of times I feel like our regulatory state undermines that, and we can really worsen the situation if Congress doesn't get a handle on dealing with the guidance that the agencies are now issuing. I'm glad to say that there were two task forces in the House of Representatives this week put out reports. There was one on regulatory reform and one today. In fact, as we're speaking, they're doing a press conference inside the Capitol right now on Article 1 and separation of powers. And both of those task forces, guess what? They address this phenomenon of regulatory dark matter and agency guidance. So I feel like we're potentially getting some traction on this, because to me, as someone who works on the regulatory side of things and on the hidden tax of regulation, I think it's one of the most pertinent issues that we're facing right now. I'm glad to see Congress at least talking about it, and I think it's a good time to be doing it too, as we're getting ready to move into the campaign cycle here.
There's a lot of talk in terms of trying to rein in these agencies and these actions. I guess one question is, how did it come to be that? I think a lot of people, how can these agencies do this, act outside of any sort of rule of law process? Let me play devil's advocate. Is it really that costly? Do we really care? And and one imagines all sorts of private players benefiting from it, and this being another way that they're able to do this. But the question being, if we don't even know, if we can't even quantify the regulatory dark matter and what it really costs us, does this mean that things like the REINS Act really are not able to address the situation to begin with? If you can do all sorts of things that are never even get reported to the Congress, that we're not really aware of, except for if you're affected by it, then maybe these formal attempts to rein it in don't really matter.
Yeah, that's a very good question, and it's a very good point. As you mentioned the REINS Act, and the REINS Act is a piece of legislation. It's passed in the House, not the Senate, and it says that when an agency issues one of the big fat regulations, the so-called economically significant,
which is
government, in $100 million
okay.
annual effects. Annual effects either way, usually cost. It's rarely the other direction. But the REINS Act said before that rule could take effect, Congress would have to vote to approve it. Now, I definitely favor that, and I favor it in a context where they repeal some of the statutes that authorize these agencies in the first place. All of that stuff. But right now, there is something in place called the Congressional Review Act, where Congress can raise a resolution of disapproval against agency rules, but it doesn't really do that. And guidance documents, technically, and I've had conversations up on the Hill about this because they don't pay attention to it, but guidance documents technically are supposed to be submitted to Congress so that Congress could potentially issue a resolution of disapproval, and they don't. And so that goes along with what you just said about, are the formal constraints really going to work? What matters, and I just put out a piece on Congress reining this stuff in. I think with respect to guidance, and my message when I had a couple of Hill meetings was, you have to now forget the term guidance, and you have to treat everything as if it's a rule. You've got to treat it. There can't be any guidance anymore. Anything the agencies do has got to be acknowledged as a rule, one way or another. And you are going to have to do REINS-like approval of what they do. And if you want to do a lot of that, if I don't know, FDA has a bunch of little advisory letters that's sent out or something like that, you can approve those in block. You don't have to do each one individually in time of Congress, but you have got to take accountability for this stuff. But so those are some of the proposals. We're starting to see proposals trickle out for saying guidance has to be better disclosed. There's one thing I did, Rich, when I was doing the 10,000 Commandments, and I realized there was all of this guidance out there that nobody had really cataloged. So I wrote a paper, I published it late last year in December, and it's called Mapping Washington's Lawlessness, and the subtitle is A Preliminary Inventory of Regulatory Dark Matter, and the emphasis is on preliminary. I looked at what the agencies had done in terms of their guidance and memoranda and bulletins and so forth, and the starting point was a 2007 Bush was still in office then, Office of Management and Budget memos that said if agencies issue significant guidance, they need to publish that on the web, in an easy-to-find place. And when Obama came in, that was revoked, but then the chief of staff at the time, the OMB director at the time, reinstated it. It was Jason Orzag at the time, reinstated it and said, well, if you've got significant guidance and you're an agency, it can still be reviewed by the Office of Management and Budget. You can still publish it. I went to see if they did, and it's a real mess.
Yeah.
So you were asking about, can formal measures bring this stuff to grips? One thing we have to do is start reporting it better, and one of my recommendations was calling for uniform reporting of the guidance, the same way we have uniform reporting of public laws and uniform reporting of regulations in the Federal Register. How exactly you do it doesn't matter so much as that you do it. But I toted up 580 pieces of so-called significant guidance that the agencies were at least acknowledging. But the problem is beyond that, I don't know what you would call it, sub-significant or secondary. I think secondary was the word I used when in a new spreadsheet I put together. But of all of the stuff that doesn't get called significant that's coming out of the Consumer Financial Protection Bureau, which is one of the new agencies after Dodd-Frank, doing a lot of guidance. They're regulating everything by guidance without doing regulations. And so I started looking, you could find like the St. Louis Federal Reserve, and then a trade group started pulling together numbers of guidances that affect the financial sector. But I realized this is extremely haphazard, and so when I do a new edition of the Dark Matter Inventory this year, I think I might see some improvements. But it's really going to take Congress to act and start to treat the guidance as rules, start requiring it to be disclosed, and then Reins-like to start requiring of itself to acknowledge and to approve the guidance before it can become effective.
Yeah, you mentioned you mentioned Congress in here, and I guess we should say, I know our readers, our listeners are probably thinking this. I mean, these are all agencies created by Congress.
That's right.
Ultimately, and are the creations of Congress and have ultimately been allowed to do this.
That's right.
So we're getting now to like a basic fundamental value of our constitutional system, which is separation of powers and how they're going to manage delegation. And that's, in a lot of ways, this also comes down to delegation. And is this constitutional? Most people now, we seem to be, yes, of course. And how possibly could we have a federal government without this large regulatory state? Switching fields here, you were in a discussion, was it last month or 2 months ago, on Cato Unbound, and Adrian Vermeule said the title of his essay was "What Legitimacy Crisis?" And he says the regulatory state is giving Americans what they want. Congress, there's no way Congress could really act in all of the necessary ways that is required. And, there doesn't seem to be much of an outcry from the public. And this is sort of a part of what it means to live in a late modern democracy, is to have this massive entity. So, my question is, if we're in a legitimacy crisis, how would we come to that determination? Could it, you and I are talking about regulatory dark matter, but is that just part of postmodern governance now? I think people are getting up on their hind legs, upset about the growth of government. I think we've seen it and if you'd read my responses there, I think I did. We were going. We were going back and forth on this issue, and I thought, my gosh, we really have a conflict of visions among people in the country in terms of the administrative state and what counts as legitimate delegation. It's really fascinating to me, because I see the Constitution as quite clear as a limitation on government and what government can do, and that it wants to basically have the federal government leave us alone. And if there needs to be intervention,
that the states can do it, or you leave things to individuals. I thought that's such a crystal clear thing that when I read posts from someone like him, it never fails to astonish me. But we did have, you have to look at something like that debate in the context of, we did have a progressive era, and the progressives did write their books, and they did claim that rule by experts was a good thing to do, and they helped establish a Federal Reserve and an income tax and a massive array of bureaucratic agencies, thinking that in a complex society that you could have central management. I think as a society gets more complex, you're less able to have central management. But both parties are implicated in this. The Antitrust Act came from Republicans, the Department of Energy, even the Environmental Protection Agency, Consumer Product Safety Commission. Those were Republican endeavors. So it is the case that you have both parties who have contributed to the now established administrative state that we have. And so they have granted it legitimacy in that sense. As someone who comes from the perspective of, Congress ought not make a law, while others say, there ought to be a law. I come from the perspective that legislation often complicates things, and that private ordering of things like the future of drones and driverless cars and safety with respect to robots and artificial intelligence and nanotechnology, it is vital that you have regulation come from the private sector. Implicit in that debate on those who are defending regulation is that regulation actually regulates, that it protects. I don't think it works. I think there are grave problems with what it does in terms of incentives and what it does with establishing cronyism. I think, I want there to be a free market in drone package delivery. I don't want to have a Sam Insull or Theodore Vail of the drone market. I want there to be free markets. But you have, even in the tech community, you have a lot of folks who are looking for subsidies, and looking for regulatory standards and things like that. But life is complex, but you can't deal with complexity with bureaucratic agencies that can't even move. I was just talking to a colleague this morning about air traffic control and drones, and he was saying, everybody's talking about using GPS and free flight, but because of moving away from central government air traffic control. And he said, but since the regulations back in Wired was predicting back in the mid-'90s, he said that we were going to have free flight, within 5 years, and here we are 20 years later with still the same air traffic control. The regulators put us in a box, and we just did the same thing to the Internet. The regulations that will come from FCC, or not, as I said, with dark matter now, they regulate without writing anything down. But the new strictures coming from FCC on net neutrality, those are regulations that applied back to the old monopoly phone system, which was a government-granted monopoly. That's a funny thing. Natural monopolies, it's hard to find them in nature. And the old monopolies in electricity are now being applied to the Internet, and I think it's extremely inappropriate. So that's the thing. You have this real conflict of visions of what it is that actually protects society and what it is that actually regulates. And I'm of the mind that and it doesn't even matter which area you pick. I mean, even with the Affordable Care Act, the agencies can't budge when it comes to the need to dealing with new treatments and things like that. The agencies, it takes them years to get anything done now.
Yeah.
So I think it's a grave problem, and at the very least, I think with the questions that have been brought up over the past year and that have come about in this campaign cycle, the question of is the executive branch exercising too much power, which is a big part of the debate now. And I say yes, but I think Congress exercises too much power too. I think the agencies exercise too much power. I think the courts in affirming net neutrality this week make mistakes. So, sometimes I think it's like the executive, legislative, and judicial is a big rock, paper, scissors game. I want limited government, and they have to work. We have to have a society. If that's going to survive, we have to have a society that believes in people and thinks we do manage our affairs, and we don't want to be in each other's business all the time. But we do want health and safety and protection, but we have to have a real debate about where that comes from. And
Yeah, but
My view is it's not from regulation all the time.
no, and I would agree with you. I mean, it would seem to be the case that the more complex society becomes, the technology and the economy, that the less role there would be for a central
Wouldn't it?
government. But so the contrast is Vermeulen and Posner in their book a few years ago arguing, no, that type of society demands the agile executive, the agile regulatory state operating without a lot of constraints to meet these different demands. And of course, he goes so far as to say with his co-author, Posner, that really we really don't even need Congress doing that much. And he says the executive, and he points to crises. Executives meet crises better. Congress dithers. And then there's something there, Chris DeMuth also arguing, there's something about a postmodern society that doesn't really understand Congress and deliberation and compromise anymore. So there's something about the increased access to government that it wants that the executive gives. And so it seems to me that's where sort of the battle is. It is interesting.
Well,
some have argued Congress is also not even a player anymore, and it's
irrelevant.
chosen to become irrelevant.
Well, we did decide not to have a king, and there were, you did have some founding fathers who verged on wanting one, like Hamilton, but we decided not to have a king. There are countries that do, and those kinds of views, it's so interesting that there's so much public debate, just in the public arena, on democracy and accountability and making sure that everybody is represented and that everybody has a voice and that civil rights are protected. The whole idea of democratic accountability is central to our whole way of life. And yet getting rid of Congress, which is the entity that's most closely linked as representatives to the views of the people, gerrymandering and all that aside, Congress is the one that does best reflect the will of the people. So I see those kinds of views as extremely undemocratic, and I said so in the Cato Exchange. Congress is the entity that our Constitution imbued with making laws. The problem now, although it's not a problem to the folks you just mentioned, the problem now is that Congress is not the entity that's making most of the laws. It's unelected agencies that are doing that. How do you have accountability in that kind of world?
Yeah. Well, question two that sparks to mind is a new Administrative Procedure Act. If we aren't going to get rid of the regulatory state, it seems that we aren't. But what we could do is, Wayne Cruz is writing about the regulatory dark matter. So we need a new APA that reflects this and tries to bring it under control, regularize it, transparency, et cetera.
I'm glad you said that. I don't want to settle for that.
Yeah,
okay?
No, I know. I'm sure you
here's
don't.
what I would
I'm sure
say.
You don't.
Right. I know you do, and here's what I would say. I always say, most of the world's wealth has not been created yet. Most of the jobs have not been created yet. And then our general counsel jokes back at me and comes back. He said, "Yeah, Cruz, but most of the regulations aren't written yet either."
Yeah, that's right.
Here's what I think. And this is what I express a lot in a lot of my writings. We have all the regulations that are in play now. We have all the regulations that we're debating right now, and then there's everything that's yet to come. And I take this view of the regulations that are out there that already exist. We need to do something like a reduction commission to deal with them the way we deal with closed military bases and things like that. But when you talk about new worlds in new realms in cybersecurity or robotics or something like that, or even drones, like just theoretically, you could imagine, given GPS technologies and the tracking capabilities we have, not that anybody would want it, but you could pack the sky like a neutron star with drones if we had the right kinds of property rights and contracts and arrangements like that. But yet what we're doing instead is saying that, and it's already happened, the FAA is moving right in with the standard 50-year-old air traffic control system to regulate these kinds of things. So I think for future regulations, very very important in reigns like the act that would, if we're passed, Congress would have to approve regulations. Very we need a real heavy-duty sledgehammer reins-like treatment for everything new that agencies want to do in any new sector. For example, this FAA ruling on net neutrality ought to be completely null and void until Congress approves it. And Congress hasn't legislated to give FAA the authority to regulate drones. So anything FAA says on drones ought to be moot. Same thing with driverless cars and the Department of Transportation, or even now the FCC, wanting to regulate driverless car communications. Congress hasn't passed any law giving them authority over driverless cars, so anything they say should be moot. You see where I'm going? Yeah. It would have to mean that Congress would have to do something, have to have something that doesn't have now, and that is a vocabulary for legitimizing free enterprise.
Yeah.
And they don't have that. They even when they're attacked on when they try to debate net neutrality, they say, "Oh, we'll make sure that they don't block, that they don't throttle." Congress has to come. That's a real problem we have, and it's why the progressives and folks like you mentioned, like Sunstein, who want the administrative state win, is because all of the complex areas. Remember, property rights and capitalism are essentially a new human creation, but all of the kinds of property rights of the future that are complex and intangible, like airsheds and watersheds and spectrum, and ownership of drone pathways above your home. All of those kinds of questions are extremely complex, and they're the ones that we need to be answering, and yet they're being ignored because we already have giant administrative agencies who are jumping in and preempting the very development of property rights and contracts and market institutions in those areas. You see what I mean?
Yeah.
And so when I had Vermeule come back and say, well, we need these experts to make these decisions, I said they don't have any expertise. The real expertise would involve recognizing, oh my God, property rights and contracts are the foundation of wealth creation and growth in the country, but we don't have those regimes in these new areas. So real expertise would be devolving the regulatory state in favor of those new property rights and contract regimes. It's a completely different view.
It's interesting too. I mean, when he says experts, we're talking about lawyers, really.
Right.
I mean, we're not PhD guys or engineer guys, who have worked in the industry or Silicon Valley. They're not making these regulations, or perhaps they are in some consultative manner. But no, I think that's a really good point. Another question too, thinking about dollars and cents here. You think about something that's one of the most significant, to my mind, informal regulations that came out of the Obama presidency will be these Dear Colleague letters to colleges and universities, which seems to me the costs there, dollars and cents costs, are pretty low. Universities have to hire a new $150,000 compliance officer. Good for that person. But the real cost being liberty, deprivation of liberty. And that just sort of, but one sees all sorts of things like that just falling under the radar, and that's the way the OCR is operated. Pretty much, I'm told that's business as usual for the OCR. And then we just got the bathroom thing, which potentially could be a huge cost for schools who have to comply with that. I mean, of course, that's that was regulatory dark matter, although it was well publicized regulatory dark matter. It was
regulatory dark matter in the sense that you didn't have a note. Congress didn't pass a law saying that. Yeah. Congress didn't pass a law saying that, and you didn't have a notice and comment period. You just had the Obama administration sending out those letters, and you see what happens when government is so big. And here we are. We wouldn't be having this conversation if the federal government weren't so heavily involved in education, right? But since it is, it can threaten to withhold funds and get things done that way, and cause others to make decisions that they wouldn't otherwise make. But the regulatory costs are tremendous. You can see estimates that range from the Office of Management and Budget will only tell you about a few dozen billion, but my placeholder for regulatory costs is about $1.9 trillion, using a lot of government estimates. I've seen estimates from the National Association of Manufacturers of about $2 trillion a year. The Mercatus Center just put out a study saying $4 trillion a year in lost economic growth from the regulatory state. But you're right, the dark matter doesn't get counted here, and it's part of a whole array of things that don't get counted in regulatory costs. We leave out so many economic costs, like I was just talking about the institutions of liberty and of property rights and contracts that need to be applied in all of these areas, but they've never been, is a huge one. But we don't count job costs of regulations. We leave those out. And, so there are just a number of ways that we leave things out But having the conversations about it and having the debates about it and at least getting some recognition that central regulation and rule by experts is not what gets us the best social outcomes, I think is a good prospect.
Wayne, thank you so much for discussing regulatory dark matter. Your great work, your innovative work in this regard, and good to see that more people are joining you. And wish you every success.
Thank you so much. I appreciate it.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.